the transfer of sensitive data across borders, they usually hinge on two parts. One is reciprocity, and the second one, like in the case of Germany, for example, there was a requirement to uh, register and, in effect, seek approval for the transborder release of data or sharing of data. So those were specifically two areas that we wanted the Commission and Committee of the Bill to take a second look at. So actually, the final point is in the Constitution of the governing body, of governing board. Like Prof said earlier, the comment for us was basically to extend, because there is an inclusion of data controllers as part of the committee setup. While we didn't initially comment on the other stakeholders, we're particularly interested in the inclusion of data processors. So the bill is very strong around data controllers, but more often than not, most of the data controllers usually are entities established here, whereas most data processors may not be. So it would be interesting to take a look at the bill um, from cross-border sharing of data, particularly with third-party data processors that are not within the region. Okay.
All right, thank you very much.
Yes, another comment. Good afternoon, is it still morning? It's morning panel, and first and foremost, I want to thank the promoters of this. My name is Dr. Stephen Bassi. I'm a visiting scholar at Center for Cyberspace Studies at Sarawak State University. And I thank the promoters of this because this is like a continuation of the 8th assembly that I was myself, Dr. Baniso, ABM Odo, and I think I see Rukuyat here, Tani, and there are those of us that started this process of the bill. I just want to go on a comment on this data localization because I heard my sister from UNICEF make it. The philosophy, like Prof says, the philosophy and principle of data protection is simple. If you kick against the data localization, what are you going to protect? What do you protect if you don't? We talk about infrastructure. You want foreign countries to bring and invest, and then we still go through capital flights. We have that. There was a suggestion during the sessions we were going on. We had a reason to have our data localized here. How do you control something that you don't see? So I don't think that should be an issue. Sometimes when we want to talk, we should have some little knowledge and foundation on what we want to talk about. I mean, with your apology, because I know a lot of people talking about cybersecurity. We don't understand the basic philosophy and the principles of it and behind it. The NIST framework, version 1.1, actually state out the 5 pillars of this. And for us to be able to make our data protection bill strong, we had one that went to the National Assembly on the 8th Assembly. Data localization is one of the key that will create jobs, not only about our national security, but also the national economy of this country. Because our GDP has to be grown. We have to get our youngsters to be able to be innovative and be self-employed. So I think on that note, we should please just realize that there are reasoning. Forget about the infrastructure. We can get donors, we can get funders. Let us get a grip of some of us who are in the intelligence community. I came in from the US. We know what happened with our information outside simply because most of our data are not here. And we don't have control over them. Just to make it short, so I followed the principle when he was asking, do we need agency or we don't need a commission? So please, let's actually, I don't want to go further comments and other things, but I've seen so many comments. We took time because we went on a retreat on this bill. And then I thank the team, the legal team that is still working on this bill. It's good to start to bring this thing. Let's brainstorm a lot, but let us have the basis understanding of what is going to benefit this country. Thank you. Thank you very
Thank you
much.
very much, sir. Um, I've just been informed that some of our colleagues online wish to join us. Can we switch and get Wumi Faiga on now? Are we ready to switch to Wumi, or we continue with participants in the hall? Okay, so let's continue. Is she connected? Wumi, can you hear us? Wumi, can you unmute your mic, and if you hear us, can you say something? Hello, Wumi Finder. You've been given access to speak. Can you hear us? Okay, so we'll come back to Wumi. So let's take the next comment, please.
We don't have
No
for
comment
now.
for now.
For now. So we can take reactions. Okay, we have one. Alright, sir.
Thank you. Good morning, everybody. My name is Jonathan. Project Manager, IT Bank of Agriculture. We have actually looked through the great job that has been done by this committee, and though within the shortest possible time, we forward in our um, few comments. But then let me just pick few uh, that I feel that our attention could actually be drawn to. On the part 5, section 28.2, under the processing of sensitive data, it says that where a decision which significantly affects a data subject is based solely on automated processing, the data controller shall, as soon as reasonably practicable, notify the data subject. So we have that word, as soon as reasonably practicable, we look at it that it may be subjective and may require value judgment and much interpretation. So as a regulatory statement, we have the opinion that it should be specific. And secondly, the issue of the individual the data commissioner who has been given the responsibility to manage that function. We have the opinion that it is a responsibility that goes beyond just cognate experience, because cognate experience too could be subjective. We are looking at the fact that there are certain minimum requirements in terms of professional certification. For example, if you are talking of someone to be the accountant general for the federation, there are minimum qualifications you expect that individual to possess. He must be a chartered accountant. So we have the opinion that that individual to handle such sensitive function should have professional certification qualification that is, not subject to subjectivity. There are a couple of them out there. ISACA is one of them. ISC Square is one of them. So we can actually look at that too. Then we also consider the 41. You see the data 41 part 9, section 41, subsection 1, that the data controller or data processor who fails to comply with the notice commits an offense and is liable on conviction on a fine as may be determined and imposed by the commission. We're also saying there may be need to specifically state the fine, because if we say it may be determined by the commission,
may also be subjected to further interpretation. And then finally, part 10, section 43, subsection 1 and 2. Regulatory statements should be direct. It shouldn't be subjected to discretionary decision process. Using the word may as against shall. For example, it says that the trans-border transfer of personal data may only take place where an adequate level of protection based on provisions of this are secure in the recipient state or international organization. While in the subsection 2 of it, it's also saying the commission shall ensure that where there is a mobile transmission, parties shall meet minimum requirements. So one aspect is saying may, which is subject to discretionary decision making. The other one is saying shall, which is a direct regulatory term. So many efforts have been put in place. We appreciate the effort that has been made so far. So thank you very much. We will forward our little comments in addition.
Thank you very much.
Thank you very much for that. Just by way of slight response, um, I understand what you're saying, but when you look at that last provision you were talking about, the discretionary provision is on the processor. Is on the processor, while the obligation, the mandatoriness, is now taken from a point of view of the data authority, who must now ensure that that processor, before they do the transborder processing, has met the minimum requirement. So while not removing from what you said, yeah, the intention is that if the word was sharp, the feedback would have been there are so many impositions. So you create the room for the processor to know that I must operate within this framework. There are minimum requirements that have been set down. It would have been a different matter if those requirements are not. The requirements have been set down. I am now aware that this is what I must comply with before I process information transporter. Now, if I fail to do that, then the commission can now come in and ensure that that is properly done. I don't know if it fits with what you were talking about. Thank
Good afternoon. My name is Razak. Hello. Correct. Something. Comments actually. In section 8, we feel like we need a representative from the Council of Regulation of Engineering to be on the board of the commission because we have like professional skills, web professionals that can handle the security side of the data protection bill. Um, um, so we need a representative of licensed engineers of technical security from the Office of the National Identity Management because we feel like everybody that is on the like some people on the committee should be registered with correct so that we can fully and effectively talk about the engineering Nigerian sector.
Sorry, sir. Can you come again with the name of the body you're referring to?
Council Regulation of Engineering.
Correct.
Correct. Yes. Yeah. Because we feel like and we have engineers and we have skilled engineers that can actually be part of this committee. That's the commission, and they want to try and want them to know.
Thank you.
Thank you very much. Before we continue,
Okay.
Few comments because we still have some time. I think we should still engage more. There are some areas I think as stakeholders we still should chip in. I will feel member to say one or two things concerning those that we registered as. I know they have submitted something, but it's time is on our side. It's good to also listen to them. Area of capacity building, enforcement. I also know that in the draft bill, there was also something concerning penalties, fines. People said it was too high. What do you think about it? Is it what you find now? Is it okay? Do we, reframe it, or do you want to make contributions concerning that? And then issue of data localization that was raised. I know one or two agencies are not too comfortable about it. Let's discuss it so that at the end of the day, we are all on the same page. And then when this bill goes, there won't be people going behind to, we know how these things work. At the National Assembly, then that's the purpose of this stakeholders meeting so that everybody will contribute. Say your mind out and let us share all these ideas, and then we all agree. Even though it's difficult for all of us to agree, but then we compromise here and there, and then we favor whatever is going to be sent forward. I think thereafter, we might give opportunity to the right now, LRWG to clear some doubts. I know my co-pilot here, Femi, has been doing a good job, but I think some other members of the committee may also have one or two things to say. So please feel free, contribute a lot because this is just a very important opportunity we have to say our minds out. Thank you.
Thank you very much, sir. So we have some colleagues ready online. Let's switch over to Carol Robson. Carol Robson, can you hear us? Okay, we can hear you, but can you speak up, please?
Yes, sorry. Are you able to hear me now? Thank you so much. Thank you. Your Excellency, thank you very much for the opportunity to speak. My name is Carol Robson and I represent MasterCard, which is a global payment and technology company. I'll be very brief because we shared a written submission, but very much our perspective is from a private sector entity that will be implementing the provisions of the bill. And so I'm very much focused not on the principles of the bill, which I think we first thoroughly support, and I certainly agree with many of the comments made today, but to look at the practical implementations of those comments. In particular, making sure that there are mechanisms for subjects asking for rights to their data, to allow controllers to verify the identity of the person requesting that data so that individual data is not given to the wrong person, that cross-border transfers of data can be carried out without the need to provide individual information to the Commission on each and every occasion, that data breaches will have a threshold for notification so that the Commission can manage serious issues and not be overwhelmed with every single instance of where data may be seen by the wrong colleague, where automated decisions, while transparency is so important for individuals who may be involved in their data, are informed about that and fully notified of that, that they're not required to have constant notifications from every company that may be making a decision at any given time, but rather have clear, accessible information that will make sense to them in one step and in one notice, and that where there is notice to be given to data subjects that companies such as ours, that is a business-to-business company, and might not have that direct contact with data subjects, that notice can be given in a practical, understandable manner and possibly by third parties. And while certainly I entirely agree with the comments around the data of children and the need to protect sensitive data, I would perhaps suggest that data relating to children and data relating to the behaviour of subjects might not be subject to the additional requirements of sensitive data, but rather can be protected by the bill as a whole, as colleagues and references have said, that the whole of the bill provides that protection without asking for consent on every single occasion, because doing so may in fact lead to effectively consent fatigue, which has been seen in Europe, has been seen in the UK and in the US. And so overall, references, thank you so much for our opportunity to comment. I think my value is very much to making the bill be something that is practical and effective, and as the Honourable Director General of the NIMC said at the start, for all of that the doing of this legislation and making sure it can be properly implemented for the people of Nigeria. Thank you so much for your time.
Thank you very much, Carol Robson. Your contributions were quite apt. I want to assure you that the comments will be considered and your recommendations incorporated to what is being done here today. If we're ready, let's switch over to Mr. Shegun Adeyemi, who is the representative of the section on business law, Nigerian Bar Association. Is he ready? Mr. Shegun, can you hear us?
My name is Shegun Adeyemi from the section of business law of the Nigerian Bar Association. First, I would like to thank the committee for giving us the opportunity to add our voice to the ongoing discussions of the draft data protection bill. The ICT committee of the section of business law of the NBA have reviewed the draft data protection bill, and we have made some recommendations, some comments and observations which we have documented and delivered to the office of the committee. However, permit me just to quickly highlight, we've made about some 43 recommendations, but I would just like to touch on maybe 4 or 5 of them, given the fact that some of the issues that we touched on have been picked up by other participants at this event and some of our colleagues. So I'll start with the first. It is our view that the subject matter of the draft bill should be amended to position the draft bill as a regulatory framework for the protection of personal data of natural and natural persons, and for the establishment of the Data Protection Commission. You will note from the subject matter that the draft bill, even though when it goes into the objectives focus on that regulatory framework for data protection, but it's couched as if it's just for the establishment of the Data Protection Commission. We're also of the view that a preamble or a recital should precede the section that gives regard to, for example, the National Nigerian Data Protection Recognition and the recognition by lawmakers to deepen the regulatory framework for the protection of personal data in Nigeria and harmonize the efforts of stakeholders, which necessitates the need to establish by statute a data protection law. This is given the fact that we already have a regulatory framework. We have an agency of government, which is NIDA, that also, in addition to its functions, already provides some kind of regulatory oversight. And we note that this bill is silent on that existing framework. We also feel that there should be an introduction of key terms and definitions section that defines some of the key words that are used in the draft bill to avoid any ambiguity. Also, the inclusion and recognition of consent as one of the basic principles of legal knowledge for processing of personal data. You will note that consent is not one of the key principles for processing in Section 4, although Section 5 appears to acknowledge consent in passing, but we believe that it should remain one of the key principles and recognized in the Section 4 of the draft bill. We also feel that there has to be assurance of independence of the governing board of the Data Protection Commission and provision for the replacement of the board member in the event of removal and or resignation. Currently, there is no provision for such. Inclusion of the representative of the Nigerian Bar Association in the composition of the governing board, removal of any type of executive influence is the removal of the chairman of the governing board. And also, we recommended that quite a number of ambiguous clauses and typical errors which are contained in the detailed document that we submitted to the committee, which we believe will be given a due attention. So on this front, and with this few words, I'd just like to give to say a big thank you for giving us the opportunity to comment on this topic. Thank you very much.
Thank you very much, Mr. Adeyemi. We really appreciate your contributions. We've received some comments from online. There's, there's a comment from Facebook from Paradigm Initiative to the effect that there's a suggestion to include the National Human Rights Commission on the board of the independent authority. That will be looked into. There's also a question here from Mr. Taiwo Adela Soye, and I can see the representative of NITDA. I would want to direct this question to him, and hopefully we can get some insight from it. So the question is, what is government doing to address IT infrastructure deficit in Nigeria? I think you are best suited, sir, to address that question. So can we get the microphone to?
Thank you. Thank you very much. My name is Emmanuel Edet. I'm from NIDA. It's really interesting that NIDA has been called out several times. That means we must be doing something good, bad. Either way, it's nice to know that they know us. All right. As far as infrastructure deficit is concerned, I'm not really sure which area we are talking about infrastructure deficit because the ICT sector is kind of dynamic and most of it has been privatized. If it's in terms of connectivity, we've seen a lot of improvement on connectivity championed by the regulator NCC. Yes, we need to go further than what we have today, but if we take a retrospective look, we'll see that we have come a long way by supporting the private sector. And we think that's always the best way to go. Government providing the enabling environment to support the private sector to provide some of the infrastructure that we actually need to run as a country. So in terms of infrastructure deficit, we I am of the opinion that NIDA has totally done what it should do within the confines of our regulatory powers, development responsibilities, as well as the funding that we have. In terms of maybe what you may call soft infrastructure, we have tried as much as we can to develop innovation by providing opportunities to young Nigerians and helping them come up with innovative ideas, which we support from time to time based on our capacity and capability. So we are on a good road, and I'm sure that eventually we'll get to the targets that we have given to ourselves as a country and to NIDA as an agency. That's for the last question. And to the issues that have been raised regarding localization, number one, and then our structure for implementation of the National Data Protection Regulation. So, NIDA's position is basically simple. We support innovation. And one of the things that stifles innovation is additional cost, especially in terms of infrastructure. So the truth is that any innovator anywhere in the world always looks for the cheaper way out of every situation. And because of this, a lot of them are forced to use cloud computing to validate their innovation. And cloud computing, even though it's been around for a long while, actually supports innovation by providing storage services cheap. I mean, with your accounts on all these free service providers, you get a lot of storage on the cloud, which is something that you may not be able to afford personally if we wanted to. So the point here is this: we believe that the emphasis should be more on logical control than physical territorial control, because the world is expanding. That's on the technical aspect. The other aspect has to do with reciprocity. We are looking for countries that have similar provision, not exactly the same, but the world has become a global village. Sorry, I have to use that cliche. We are looking at reciprocity. So, if we completely say every single personal data of Nigerians must be physically resident in Nigeria, what happens to a young man who probably travels to the US and his data is captured? He's also in Nigeria. Are we going to say, okay, before you capture his data, it must reside in Nigeria? That's number one. I'm just throwing this open. I'm not saying that's what it is. Secondly, if you want to protect Nigerian data everywhere in the world, the personal data of a Nigerian, just as the GDPR does of a European, we also have to have some form of reciprocal provisions that will enable us have cooperations, intergovernmental cooperations with every other person that holds a Nigerian's data outside of this country. Moreover, a lot of our primary servers have their secondary outside of the country. So that's another issue that has to be looked at. A lot of them, I'm not saying all of them, but a lot of them have their secondary sites out of the country. So our position is, let us have logical control of the data. The representative from Mortgage Bank Policy mentioned something about having multiple service providers. The issue is, if somebody is providing service to you, you must, at least to a certain extent, have control over the type of service the person is providing to you. So those agreements will tend to give you some form of control over those services. So you tell the person, if you're providing service for me, these are the conditions you have to meet. That is your logical control. Then on the issue of data protection compliance organizations, we as NIDA have a very small team compared to the entire country. So what we thought, and which worked very well for us, was, why don't we create an industry of data protection compliance organizations who will help us, just like we have external auditors all over in the financial sector, who will help us audit data compliance of all organizations. So more or less, they act as our agents, and then they bring these reports, and then we take a look at them, and where we identify non-compliance, we'll be able to address the issue as we go on. Of course, everybody expects us to cover all organizations and the whole of Nigeria within one sweep of an arm. That is practically impossible. There are some laws that have been existing since I knew about them, and the enforcement is still not 100%. So the point here is, if we want to have a lean, forgive me to use the word mean, a lean, mean organizations to deal with data protection, like Professor Idonije said, then we need to find innovative ways to ensure compliance. We have tried the DPCO systems, and it has actually worked for us. And we hope that, which is part of our position, that whichever authority is going to take charge of data protection in Nigeria should be able to adopt that type of system. However, they want to adopt it, fine, but would like to see that type of system to help us save money. Thank you very much.
Thank you very much, Mr.
Thank you very much. I'll give the floor to the prof just to make, ask one question. But before that, you see, it's good as we first need that to say something, and we have all benefited, right? I'm sure I'm speaking your mind. I just want to say one or two things. It's good as you have taken this step to the guidelines and all that leader has done, but how easy is it to enforce some of these things? Then the capacity, do you really have the capacity, and how, these are questions that we all should address our minds to. Capacity building aspect of it. Then, and I think issue of data localization, like we said, some of the I don't want to use bad word, maybe bad experiences we've had in the past, form this opinion. You could remember at the time, I want to believe that our data on our passport is back to Nigeria now. You could imagine at the time when it was hosted somewhere. I want to believe it's back here. So these are things that we want. How can you have passport, personal data of Nigeria is being hosted somewhere outside the country? It is painful. So maybe it's an overkill to say that everything should be here. But like you rightly said, I'm not taking brief for the committee. I just need to, sometimes you need to, let people know why certain things are being done. Maybe, and I say maybe, if you enforce that certain things should be here, that will force us to even develop our infrastructure and have data centers. Galaxy is hosting data. So many people can host data. NIMSI has the facility and things like that. It's just to make, I quite agree with you, it may not be as cheap as, it's being done outside, but we cannot continue, to leave our resources going outside the country. I leave that to people to look at the pros and cons and come up with what's best for the country. But what we are particular about is the national interest. This dollar, for everything we do, we have to also allow people to bring money into the country. We shouldn't, we will not continue this way, talking about power, talking about cost, and high cost of production. I understand Japan that is now leading the car industry. When they started, they used to push the car up the hill, enter it, and go down. To their best. Americans are selling their big cars and buying Japanese cars. If we don't take some of these destinies in our own hands, we will continue forever, and these, dollars will always be paid outside and will be at the detriment to our own country. Thank you. I think I just wanted to put that point straight. Why, certain school of thought believe that certain things should be done. I'm not saying that's the correct thing. Thank you.
Sorry, Doc wants to share. Okay, okay.
Okay, sorry. I'm glad that many of us here are from various commissions, organizations, and so on. I want to ask you one question. How many of these commissions are properly funded? How many of them? Including NIMS. I can see that we have National Population Commission as a member of the commission. They can't conduct census. Look at the composition. How many of them can survive? Apart from those that generate IGR, like NCC, NEC, all that are the paid IGO of government, at the moment, all they do is pay salaries. That's all. Then they are saying you should set up another commission to pay salaries. Thank you very much.
Thank you very much.
Yes, one more time. I just want to make a very small comment about what my brother, Braskai, just said. We should not have a misconception of data localization. If I live in US, my driver's license number, my social security number, my house, everything, data stays in America. I'm here in Nigeria today. I have a driver's license in Nigeria. I have car papers that keep my data here. It's not going to go to US because I'm a US citizen. No. I'm here, I reside here now. For this moment. Once I go back there, or if you just arrive somewhere, they give you a form to fill. That data is for their own consumption.
Yes, sir.
And then I want to say something about this cloud. Cloud is a business module. It is not a technology module. So we should not mix the understandings of this thing, because the philosophy in cyberspace is completely different from what we have in the physical space. So when somebody say cloud and so on, cloud is just a business module. It's not a technology module. So we have to get all these understandings. Therefore, yes, we are. This data localization is going to take people like Galaxy Backbone, the small data centers. They will start to implement cloud here. So I don't see why we should try to play down on data localization. When you talk about infrastructure, business is open here. They invest their money, they go and get loans. The same way, we have some people having some small businesses that they build some infrastructure. People are doing rice mill. They borrowed money to buy those machines and set those machines here to do what they want. So we can get the infrastructure set up when this thing is open to the private sectors. Because what you're still trying to say, you just want to leave everything under government. And we cannot expand with that.
Thank you, sir. But before you sit down, sir, so the issue, because it's obvious it's a thorny issue. It's not just in terms of the primary storage of data, of personal data. What the concern relates to, as was provided in the previous version, was that in processing data, the processor must show that the devices, the database that is being used, and all of the infrastructure related to processing of data is localized here. So that's the issue. It's different when if we look at the primary storage, your driver's license in the US is in one place. Here it's in one place. But like was pointed out, there was a time we knew that issues related to, for instance, your information on your passport was being processed outside of Nigeria. So that's the context of localization that is raising this argument, sir.
Good.
Okay, sir, maybe we'll leave it at that and we'll look into all the issues, sir. The committee will look into it, sir. There's a gentleman next to me, doctor.
Okay.
Good afternoon, everybody. My name is Rex Abitobo. I'm from Nigerian Computer Society. Um, our own submission really will focus on the following areas, which are some of the things that has been argued and talked about here. The issue of capacity building, which is very, very vital to sustainability of whatever we are putting together here today. Because uh, we need to look at it. The foundation of data protection boils down to security. You can't talk about security uh, when at the local level you are not doing anything to protect the data of your citizens. And leveraging on that, we'll begin to look at it really, the issue of localization, which was talked about, was debated about. And the argument from some end boils down to the fact that you drive away foreign direct investment. But the honest truth is that if I want to develop the citizen, I want to develop my nation, I want to empower people, I want to encourage creativity, innovation, we must equally encourage, instead of housing our data outside the country, okay, or having it uh, uh, being processed outside the country. When we talk about Nigerian territory, we mean we're not just talking about the physical Nigeria. For example, Nigeria embassy in Ghana, Nigeria embassy in US, if you are processing my data in those places, you are processing it in Nigeria. That is the honest truth. So we need to look beyond the physical space. We are not talking about the physical landmass. That is another thing. Then the other part which we talk about the fine. The fine really, if as a business person, if I'm going to commit a crime, that I will only be levied 5 naira for a business that I'm going to make profit of 50 naira, I possibly will go ahead and pay that 5 naira. So the amount that we fix for as penalty, I think that is something that we really need to look into. We should look beyond the small businesses or someone who feels that, okay, I'm making maybe 1 million naira turnover, 10 million naira turnover. Let's look at the big business. And with apologies to other international organizations, take Google for example. Okay, it's a big organization. they can go ahead and do whatever they want to do because people leverage on the loopholes where you make laws to commit crime. And when they commit crime, they have those things to defend themselves. So in order to prevent that, in order to prevent people breaching or breaching the law, we need that penalty to be big enough to keep away people away from committing the crime. So again, capacity building is very, very key. Data localization is very, very key. Data sovereignty is very, very key. And also because it will build innovation and creativity, and it will empower, it will create a lot of jobs for a timid youth population. And the final one is the penalty. Thank you very much.
Thank you very much, sir. Um,
Sorry, I have to say one or two things concerning the penalty, and it was deliberate, but nobody was talking about penalty. It's also, when I say neither here nor there, like you rightly said, if you're a businessman and this thing is not a criminal offense, or you have, if for instance, I'm dealing with something that has to do with volume, and I know that if I break the law, so to say, I will make 10 billion and my penalty is 100 billion. As a businessman, I will go ahead. Am I wrong for those who are doing business? And pay 100 billion and make 9.9 billion. However, I just want us to look at it in that perspective while the committee is rounding up this work. And at the other end of it is also not to scare people away from coming to Nigeria that, oh, how much am I going to make if by mistake, maybe unintentionally, I commit this offense. Then maybe we scare people away. So we can strike a balance. But someone suggested, because we also consult, discuss some of these issues, and say probably it could be put as not zero and less, how do you put a certain amount below and leave the, whatever is going to be the penalty to whoever is judging. It could be a way out, but we have to really take into cognizance the fact that business people are out to make money, and if you are going to make a billion and you are just going to pay 10 million, you better go ahead, and it's not a criminal thing that you are not going to criminalize. Then so be it. So I just needed to say a little bit about that so that when we're rounding up, the committee will put it together.
Thank you very much. Sorry, sir. Before we proceed, we have some of our colleagues online. While we have them now, let's take advantage of them. We can always come back and continue, sir. Yes, doctor, I see you, sir. I see you, sir. We'll come back to you. Let's take advantage of the connection we have now. So let's invite Martha Tempini from the.
Yes. Good afternoon. Can you hear me at home?
Yes, we can hear you. Can you hear us? Okay, good.
Good afternoon, and thank you very much for giving me Can you hear me? Yes, okay. Thank you very much for giving me the program, the opportunity to intervene. My name is Matteo Tempini. I work in the International Data Flows and Protection Unit of the European Commission of the European Union. And so I'm very pleased to be with you this afternoon and have the opportunity to comment on the draft law. I should anticipate, as I wrote earlier, that we intended to send written comments to the law. Unfortunately, we were not able to do so yet. I anticipate we'll be sending written comments in detail in the course of today. I would like, first and foremost, to congratulate the authorities for this draft law, and we have heard there's a lot of interest, and which shows us that Nigeria is intending to join the international convention, the global convergence that we see between states that are converging towards high standards of protection, like other countries in the African continent, in Europe, and elsewhere. And we believe that if this local project is finalized, we will really endow Nigeria with a modern, state-of-the-art, advanced data protection regime that is able to balance protection of personal data and of personal rights with the interest of business. We are here to see that the draft law confirms that the European Union and Nigeria share values, fundamental values in this area. And of course, we have a strong interest in this ourselves because we hope that the law that Nigeria will adopt will be convergent with ours. We believe that it's in the mutual interest to have converging laws and to cooperate in this area so that as to facilitate trade, economic cooperation between Nigeria and the European Union. And cooperation within other fields such as law enforcement to tackle international crime. As I said, we will be sending detailed comments. If you allow me, I would just refer briefly to a few of them, which we see as most crucial, most important. As I said, we see very positive the draft law, but because of the strong interest we have in facilitating future cooperation with Nigeria, we are nonetheless have many comments to try to strike as much harmonization as possible between our legislation. So I refer briefly to the scope application of the law and its exemptions. For instance, we have noticed regarding the personal and territorial scope of the law. It raises some questions in our view. The fact that pursuant to section 2.3 of the law applies to data subjects, whereas it might be more appropriate not to make them the antecedent of the law, but rather should apply to data controllers and processors, or the inclusion of any person who maintains an office, branch, or agency through which business activities are carried out in Nigeria under Section 2.3. Believe, this could be a bit broad, since it might then bind also business activities that are not related to data processing. From our perspective as a third country, as the European Union member states, we think it would be very important that this act covers the processing in Nigeria of the personal data of foreigners, and should be EU citizens, including when such data has been transferred from a third country to Nigeria. So, for instance, personal data of the EU citizens that is transferred to Nigeria. This would greatly facilitate transfers from third countries and economic activities between the EU and Nigeria and database services and other sectors. I will make one last reference, if you allow me, as regards to the exemptions. This is another point that we consider is crucial. The draft act contains provisions as regards the exemptions to the law, and we fully share the view that the right to data protection is need to consider that a fundamental right is not an absolute right, and it may be locally restricted in certain circumstances in order to protect other rights or important objectives of public interest. However, in the law and precisely in section 35, see this extensions that are provided as very broad, as sort of lack of exceptions, which would then identify what types of important public policy interests can justify restrictions to the rights of data subjects to privacy and data protection, and subject those restrictions to requirements that should be laid down in law, respect principles of necessity and proportionality, so that the rights of data subjects are only restricted to the minimum that is necessary and according to the law. As I said, we will have several other comments. Not take more of your time now. Thank you again for giving me the opportunity to intervene this afternoon.
Thank you very much. Thank you very much. Very comprehensive. Just want to reassure you again that what we're trying to do for our country is designed to meet international best practice, and areas where we need to harmonize with already existing conventions and statutory instruments. This bill will address that, and the work will be done to achieve that objective. Thank you for your time and your contributions. We look forward to the written submissions from you. Thank you. Um, Before we go back to Dr. Sir, let me just quickly take some comments we received. So there's one from Favor Femi, says there should be safeguards and some form of baseline that address data processors and controllers like encryption. So we'll look at that and to be taken into consideration. There's one from Shegun Oladejo, which says DPCOs should be dispensed with. Okay. Then there's another from Timothy Adebayo, which says Section 18 sub 5. Should data subject have the right to know the reasons for disqualification? Well, I guess maybe at the end of the day we'll see if Bill addresses all of that. Sorry, sir. Before we come to you, let's go back to what the issue, the topical issue. We would come to everyone. We're here. There's enough time. We're in good time. Doctor, sir.
Thank you very much, and I'm standing on the existing protocol. My name is Dr. Uchem Banaso. I am the Executive Director, Center for Cyberspace Studies, that's Nasarawa State University. Well, it's just to a bit of talk about the penalties, and I will really want to refer the committee back to the original draft, because the way the penalties was drafted was more better than what is present, because we factored in the issue of turnover and a certain amount, and then the turnover, and whichever one that is greater, just like in comparison with what is in GDPR. But before then, my concern is for us to really understand the philosophy of data protection all over the world. All about cyberspace today is about data, and every country is deep neck about protecting data. Every war, every conflict, every dispute in the cyberspace is about data. And so fundamentally, we really need to understand the philosophy about data protection. And the last speaker from Europe just told you that they are interested in the data protection bill of Nigeria. What does that tell you? And so we must work from a point of knowledge of what is happening over the world. The war about 5G is about data. That's simple. It's about data. And data can be weaponized in several ways today, even to harm a nation. Not only economically, but physically. So everything we are talking is just about data. And the data we are talking is not a data of that innovator. We are talking about critical data of a nation. And so I really want people to understand the philosophy. We are talking about the critical data of a nation. There is no country of its sort that hosts or houses data away from its sovereignty. No, no country. I just want anybody to just mention any country that's hosting data arbitrarily all over the world, as it is in Nigeria. So we need to be very, very careful about remove sentiments. The whole idea of everything going on in the cyberspace is about data. People say data is the new oil, is the new currency. China and the US are fighting over data, Russia with US over data. So everything's about data. So protecting our data is very, very fundamental. And that's the philosophy of all what we are trying to do. Thank you very much.
Thank you, sir. Thank you very much, sir. Sorry.
Before the next comment, Dr. Balance, thank you for your. But I was also part of that work that gave that high, if you allow me, bill. I want to believe that the committee set up now will do a good job. I personally also spoke with people, and the general belief was that it was exorbitant. And I mean, the truth must be told. And that's also not to say that it has to be too low for people to abuse it, but I'm sure the committee set up now will look at it critically and come up with something that will be the best for the country. I just wanted to put that on record. Thank you.
Thank you very much, sir.
Thank you very much. Once again, I am Anas Galadima from Alton. So I have a few more points to speak about, but I'll start by adding to what uh, the gentleman has said. Is it Prof? I think he's also a Prof. Okay. I think I support him that you can't restrict. One of the considerations that foreign investors make in moving capital and all that is the mobility of data to some extent. Yes, government data, citizens' data in terms of government data can be hosted compulsorily within the country, but for international corporations, ability to move certain data around is important for them to make certain decisions because there are companies that move around from um, country to country. So I do not think that restrict that we even the GDPR allows for hosting of data outside various countries with certain guidelines and rules. So I do not think that in my own view or in our own view, we do not think that data, especially for corporations, should be restricted within a territory, especially when you talk about certain data that are not critical to national security. So section 18, so to move to my comments, further comments. Section 18, subsection 3 provides that the data controller shall provide the data subject with a copy of personal data upon request within a period of 1 month. This is a good provision, just to suggest that some form of process be stated for verification of identity of such data subjects so that impersonation is prevented. In the telecom industry, we know that this is a major problem. If those processes are not in place, you will find that abuses can happen. Also, Section 21, um, okay, this gives the data subject the right to um, seek redress if he or she believes that his data has been misused or compromised. Also, a very good provision, just to say that we think that some form of dispute resolution mechanism should be put in place. Not all abuses must end up in court. There are things that can be escalated to the regulator or to the data controller for resolution, and then at some point they can end up in a court of law. We have quite a number of more observations, but I know that time is not on our side, so I'll just skip to another one that is very, very critical at this point. Okay, section 35, subsection 5.
Okay, this request for assessment. The bill provides that where the Commission finds that the controller's processing of personal data contravenes the provisions of the bill, it shall issue a notice to the controller specifying the contravention and give the controller notice to cease such processing. Also, like the previous provisions, a commendable one. Just to add that we think that some form of guide needs to be provided in terms of the length of notice so as to have a standard for such requests to prevent subjectivity in the process of giving notices to um, uh, um, data controllers. Thank you.
Just before the next person, just not debating with you, but to address a small point. We've said it earlier, we can't legislate everything in the legislation. And if you look further down, there are provisions which empower the data authority to make guidelines, regulations, which will now form the subject of what you're talking about. So the commission will sit down and look at the peculiarity of what those notifications should be and then issue the necessary regulations and guidelines. Thank you.
Good afternoon, ladies and gentlemen, distinguished panel. My name is Yetunde Olasope. I'm representing FinTech Association of Nigeria. Um, the company I work with, Maxit Consulting, is a member of that association. So I'm wearing two hats here, representing the FinTech Association and also Maxit, because Maxit is a licensed DPCO, Data Protection Compliance Organization. And thank you very much, Nita, for mentioning us earlier. So we call on you once again, but I'll make it very quick because I mean a lot has been said already. So I'll just go to the specifics. As a lot of people have said before I made a comment, the bill recognizes NIPTA. There's a representative of NIPTA on the board, but after that, really, there's not much said about the work NIPTA has done with the NDPR, etc. So what happens if that isn't done is there might be a parallel functioning. I'm sure that's not the intention, and I'm sure that's being addressed. So that's one thing I wanted to bring forward. And to cap that, what about all the work that has been done pursuant to the regulation? For instance, about 70 DPCOs have been licensed. What's going to happen to them? I know the bill recognizes in passing, again, in its establishment and powers, that it would have the power to make regulations for DPCOs and DPOs. But outside that, there is no mention after that. So are we assuming that the regulations will come, or there's a need to mention in greater detail the functions and qualifications of the DPCO in the bill? What also happens to the audits? I know the bill says, yes, all organizations must conduct, relevant to the controller, etc., must conduct audits by the 30th of March of every year. What about the audits that have already been completed by processors and administrators or controllers under the regulation? And finally, just one mention, because people have basically mentioned all the comments that we've put through, the right of the data subject and the 48-hour timeline given to the data controller to give notice to the subject when there's a breach. It mentions the commission, but it says that notification will be given after the commission has been notified, but there's no timeline. So it kind of gives a little bit of, it needs more clarity. When what we were suggesting is maybe make it 72 hours and give a particular time frame within which the commission must be notified, after which the data subject thereafter would be notified of the breach. So those are my brief comments. Thank you very much.
Thank you very, very much. Elvis. No, just a moment.
Thank you very much, Madam, for your comment. And I believe you are aware that your association paid us a courtesy visit sometimes last week. And these were some of the concerns they expressed. which we explain to them. Like my colleague stated, the bill cannot have everything in it, but references will be made to regulations and guidelines. Because when the independent um, privacy officer or data officer comes on board, or a commission, whatever will be decided after the next review, you know, they have to come up with the details of how some of the different administrative enforcement activities will happen. It is not for the bill to be cumbersome, having all these things in place. And one other key aspect that we keep hammering on the data protection organizations, but we tend to forget the in-house data protection officers, who are the first set of auditors for any organization. So there is also a need to emphasize on that, to make it mandatory for any organization that is into data or processing or collection of data to have a DPO. And then what are the kind of training, the set of trainings, the kind of reporting and checks a DPO need to do in their respective organizations before the annual audit that comes up. And I know that in the public sector, maybe they may have funding for this kind of activities. In the private sector, sorry. Most of the concerns in the public sector is almost every agency is dependent on budget. How are you going to make provisions for those annual budgetary audits? Like, for example, this year, the DPCOs that were licensed, almost all the public institutions did not comply. Did they? Why? Because almost every public institution did not have a budget for that activity in their budget. So where are they going to source the funding for? So these are the kind of issues we sat down with your team to discuss, to say, okay, we will look at areas where those kind of things will be remedied or addressed in the final draft that is coming up. Thank you.
Thank you, ma'am.
Just one small addition, and I will just while we really thank Linda for filling in the gap in this respect in the NDPR. One thing I always say, I'm not a lawyer, but I know that legislation is legislation. Law is law, regulation is regulation. They are not the same. So, like it's rightly put, I don't want to be repetitive. I'm sure reference will be made to whatever regulations, policies, and whatever. But I was on a forum and I told them that you can't equate everything in terms of policy to legislation. That is the truth, and it has to be put straight. Thank you.
Thank you, sir. Before we continue in hall, let's join a colleague or one of our attendees online, Mr. Ntai Bandawa. Can you hear us?
Yes, please, I can hear you.
Okay, please. Good afternoon. Please go ahead with your comment.
Good afternoon, everyone. My name is Ntai Bandawa. I represent Ididodo and Co. Well, first of all, I would like to commend the organizers of this workshop for this laudable initiative and also to appreciate the opportunity to make a few comments. Well, we have submitted our comments and recommendations, but I would like to briefly highlight two issues. To start with, the central issue to this data protection here is the protection of the personal data of individuals. So the first issue I would like to speak on is the legitimate interest, which is a defense to the inappropriate possession of personal data. Well, I believe that there should be additional safeguards when data is inappropriately possessed, even for legitimate purposes. This safeguard would be in the form of an additional requirement that for data to be processed for legitimate purposes, data controllers should still assess the likely adverse effects of such processing to the data subject and implement measures that will reduce, mitigate, or eliminate such adverse effects. Then I also believe that there should be a disclosure to a data subject of reliance on legitimate purpose for the processing of data. And if this is not done, then the defense of legitimate purpose should fail. I believe that this to prevent a situation where the privacy of personal data is protected with one hand and the protection is withdrawn with the other hand. And then quickly, the second issue I would like to highlight is is that can be seen from in section 17 of the bill, which provides that the data subject has the right to be notified of data breach affecting him or her within 48 hours, but after notification to the commission. So the bill does not provide for when the notification to the commission is made after the breach. The issue with this is that if the notification to the commission takes long, for example 6 months, then it means that the data subject will have to wait for that long before he could be notified, as his right to notification only arises after the notification to the commission. Thank you.
Thank you very much, Mr. Bandawa. Thank you very much. Yes.
Yes. Yes.
Okay, sorry, can I sit down, sir? So, okay, there were some questions sent to the email. One is specifically directed to NIMSI that with regards to data capturing by NIMSI, harmonization and sharing with other government agencies, a number of government agencies and ministries are not digitally equipped for seamless data transmission and management. How do you intend to handle data sharing with such organizations without compromising data security? I believe the question is asked looking at the situation as it exists now. If we will all recall, about a month ago, there was a committee constituted by the President of the Federal Republic of Nigeria on data harmonization, and they have submitted their report. Part of the recommendation in that report is to make sure that the technical and security safeguard required for seamless harmonization is carried out, is approved by the government, and we are still awaiting that. Most agencies under the ecosystem are getting their systems ready for that particular exercise. So definitely for uh, it's data harmonization, not sharing, as stated in the question, is to harmonize to make sure that every existing data has the identity token NIN attached to it. So the necessary safeguards are being put in place for each and every agency. And then secondly, for data capturing NIN enrollment in diaspora locations where the data protection law is a bit different from what we have in Nigeria. E.g., example, children do not undergo biometric capturing in most Western nations. How can we ensure there's an alignment with the data protection law of the host country? I think this is this question is given because even in Nigeria, capturing of persons with minors who are under 16 years of age, biometric is not mandatory because their enrollment is tied to the identity of their parents. So either of the parent or guardian must have enrolled and be issued with an NIN before the enrollment of a minor is carried out. It is only at the time when the minor reach come of age, that is above 16, that they go to the center for their biometrics to be captured. Then Nigeria has, and then we, for our diaspora enrollment, we make sure that our licensees who are operators in those jurisdictions follow the standards and requirements for each country. So that is why even it is mandatory for every institution capturing data for us to have a data protection officer. That is the only way they can, that is most of the requirement, especially in EU and the UK. They must have one that ensures that data is protected and secure. Nigeria has a high population of illiterate, semi-illiterate people who do not understand the details about me. NIMSI need to know, okay, this is on sensitization. So, like my DG always says, sensitization is never enough until we register the last person on earth, and that means that will be in perpetuity. Because even if we populate the database today, the growth rate of Nigeria is more than 7 million annually. So that means enlightenment and education is a continuous process and cannot end.
Thank you very much, ma'am.
Thank you very much for that insight. Good afternoon, everyone. My name is Usman Yusuf. I'm the representative from the Nigerian Society of Engineers. I work in the database and IT unit of the society. I would like to approach my comment. We have sent our comment and observation earlier last week to the provided email in the invitation sent to us. And I would like to approach this bill in a different approach, different from what other agencies have said earlier in the Thursday session. I must say I'm very glad this bill, as is proposed and is being reviewed presently. I will be happy if after validation and implementation and approval by the Senate, if it is implemented, because there's um, a section that actually talks about data protection of data subjects, which concerns myself and the likes of me in Nigeria. By likes of me referring to young Nigerians, especially the youth, because our data have been abused by some security agencies, especially the anti-robbery squad, the SARS. Because I've been stopped several times on the highway driving or badly going on commercial vehicles where security agencies will stop the vehicle and require me to open some information that are private to myself, and I have been seeing comments on social media regarding this abuse of information and data and privacy, where they will enforce badly use force for us to open our bank records and some personal messages on our phones and use this um, privilege they have to abuse our information. So I'll be very glad if this bill is being implemented and some measures are being taken to protect and to safeguard the data of Nigerian youths from abuse by some security agencies, as stated in Section 64, that some certain warrants needs to be obtained and granted by the judge before any authorized officer can go through your private information, such as your bank records and other private messages that you might hold on your devices, be it your computer or mobile phone. That is my observation. And also, I would like to make a request similar to what my brother from Koren has stated earlier. If the the organizers of this workshop can actually grant the Nigerian student engineers maybe a slot of for us to nominate a member of some of our members which have expertise on or probably a member of any chances, so that we can also provide our expertise in achievement of this bill. Thank you so much.
Thank you very much. Your comment on the nominations just brought to mind something I wanted to address the lady from FinTech. When you look at the composition, apart from NITA being mentioned there, there's reference to the organization of practitioners. So that can serve as an umbrella body for the DPCOs also. But that is if, depending on what the composition would look like. So next comment, please. Okay, sorry, hold on, please.
Sorry, did I hear you well that security agencies stop you on the way to look at your bank account? I can't comprehend that. Is that true?
It does happen.
Okay. Well, it's news to me. So, okay, I think thank God that the bill is coming up. So I'm sure awareness will go down to the security agencies that. I'm not aware of that. SARS stop people to check, to open their phones and check bank accounts. And then the other aspect is still coming to what Prof said. In fact, I was just joking with Prof that at the end of the day, the commission, when it's set up with everybody now coming in, they will need this hall with physical distancing to hold to hold public. So I think the committee will look into that. I'm sure with the commission, if it's approved, will find a way to, to make it such that it won't be overbloated and to take care of what it needs to take care of. Thank you.
Thank you, sir.
Thank you very much.
Sorry, sir. Sorry, sir. We're here. Let's not lose the connection we already have. So we have Dr. Godson Hero online. If you hear us, sir, you've been given access to speak. Can you hear us? Dr. Godson Hero. Okay, we'll come back. We'll come back to Dr. Hero. Sir.
Well, thank you again. My name is Dr. Solomon Isong. I'm also here on behalf of Koren. I know my colleague has made submission for Koren, but I want to reinforce. I want to reinforce local content, like a doctor from a university here and the one in diaspora, like said earlier. The local content cannot be overemphasized. We can't look down on local content. And also want to speak with Nita that we also are prof. We respect that though some of the agencies are not well funded and all the rest, but we need to get this institution right. Because it will create jobs, and we also have our own infrastructure here. And let me also say that while I'm intrigued with this bill that has come up, of course I've published some papers on it, and that's why I'm so excited that this bill is coming up. That like my colleagues, the doctors have said, if all our data are hosted outside Nigeria, I know we have things like SLA, like service level agreement, and some other form of agreements that will protect our data and all the rest. What if in the event that even with those agreements and all the rest, we lose those data? We may want to go to international court and all the rest, but those data are gone. Whether you are in court or you find those organizations and they pay, but you can't have those data back. So, in as far as we want to patronize foreign business people on data hosting, protection, and all the rest, our local content, we need to have a infrastructure established such a way that our data will be hosted in-house here in Nigeria. And I really want that to be looked into. If you allow me to use the word, I would say I want to lobby for that. That we have our data hosted in-house. We may have it duplicated because of other things. Thank you.
Thank you very much, sir. Okay, so before we continue, let's go back to Dr. Iro. Dr. Iro, if you hear us, can you proceed?
Yes, sir. Yes, I can hear you. I can hear you, sir.
Okay, please go ahead with your comments, sir. Yes, please.
Yes, please. Yes, sir. Okay, I can hear you, sir. I'm Dr. Robson.
I'm representing Isaka Untitled Chapter. Just as we had earlier made our presentation, our comments sent to the committee, but we want to thank you first of all for organizing this. Because issue of data is not it's a very critical thing, and for everybody, data privacy is very critical. And ISACA is among the, is defined the largest organization of privacy, cyber security, and IT professionals. So we have made specific, comments on specific areas. But I want to quickly go to what you say about the data, the rights of the data subjects. We are saying that subsection 3, section 73, subsection 3 should be specific. It should be explicit. Means of notification.
Dr. Miro.
Hello.
Yes. Can you continue from section 17? That's where we lost you.
Do I go on?
Yes, please.
Hello.
Please go on.
Hello. So we are saying the list of notifications should be specified. Will you choose the social media form of Twitter handle or which other way? And also we have to make sure that in terms of the newcomer or even the Evidence Act, it recognizes electronic means of communication. So that should be captured. We're also talking about processing of issue of handling a breach should be very clear. Processing is an issue. It's a different thing. We have to make sure that when we make strong processing in this act, in that processing should be clear when we're talking about processing. Then we're also talking about that the data controller. When we talk about the data controller and the entity where the breach occurred, should be responsible to make his report. Is the data controller who suffered the breach should be able to make the report. And then we also on section 38, subsection 4, we raise also issues like where we say may should not be there. May is non-binding. There is no obligation to conduct an assessment. That's what I think that should be changed. I share. Then we also say that data subjects should not be the one to pay. It's the entity that suffers breach should be able to pay. So actually the data subject to pay is a discouragement. Most of the data subjects might not want to go and make a report or because it's additional cost. So we also talked about generally the section of, for instance, on section 18. We say excessive delay. Excessive delay is ambiguous. It should be specific. We should set a timeline. We cannot be saying making a general statement. We also talk about general comments. We are saying also that the wording of the bill should be revisited. It should be revisited. For instance, in all instances where the data subject should be communicated, it should be the time should be included, the time frame. When you say, for instance, within 2 weeks, and who is responsible for the notification should be clearly stated. Anything that will bring and peace, and that's why we are saying it should entirely, the news entirety should be revisited, should be avoided in that proposed act. Then we also talked about replacing on section 29(1). We should replace the commission should determine the compensation. So when you are talking about compensation, and that compensation is for instance left for the court needs to be guided. So we are saying there should be the commission should be able to say these are the compensations in categories of compensation. That will enable the court people when they are taking decisions on that. Then also section 31, which we are also asking that physical measures for protection should also be added. Physical measures for protection of data should also be added. Uh, we also talk about section 26, subsection 2C. A case in which someone is under duress, should be added. That should be also added to them. Then we mention on section 26 2B, minor. We are saying that minor should be used to replace the word child, because an elderly man that his father is still alive is still a child to the father. So why don't we use the word minor, which is already in our statute books? Then we also said that some of the statutory errors, like section 24, subsection 2, a statutory error says data controller within 1 month days. That is not clear. I think that they meant 1 month there, or was it they meant? So that should be clear. Then we also, I'm just speaking the key areas. Then we, as an association, made up of IT professionals, and we are also saying that ISACA, members of the IT community who are members of ISACA should be, that they should consider, including ISACA in the board, because this is a professional and core area that needs to be properly addressed, and people who are used to issue of IT and data protection should be properly included in the board. Then under the end of year report, you look at section 5. You say part 1, section 5. You say 30th of March. We are saying it's too close to the end of year. And even at that the month does not end 30th, it should be 31st March. So we are saying whether that can be amended, she said whether you can shift it from 31st to maybe April ending. Then it cannot be changed. Let it be 31st, so that we'll be sure that it is 31st, not 30th, because 30th is not the end of year. Then when on part 1 to section 2, subsection 2, needs definition where you talk about personal or household activity is too ambiguous. You say it is subject to different opinions. People can interpret it. Subsection, we also say section.
Doctor, sorry to interrupt you.
It does not cover the whole business entities. So we are saying, for instance, business enterprise, this should be clearly, stated, so that we will ensure that all the business entities, are captured.
Doctor, sorry to interrupt you. We'll just ask that you kindly round up. We understand you have submitted your comment. Can you just round up your presentation, sir?
Okay, thank you, sir. Thank you. So we are running up and saying part 2 on section 5 of section 1. Privacy policies are usually lengthy and unwieldy. Then we are saying, how can we control this to show that the data subject has understanding of what was said? For instance, in GDPR, it tries to pause the processor to make it clear and readable. So we are saying NIST should be able to say that policies are null and void as they violate the rights of the data subject. In other words, if there is any policy, even the fact that the data subject has clicked on it as consent, even if it violates it, that means to be able to say it's null and void to the extent of the contradiction or contravention. Then we also know that
Doctor, sir. All right. Thank you very, very much. We see your contribution is lengthy. would your submitted comments will be reviewed. Thank you very much. So next person.
Yes.
As we begin to round up, let's make our comments brief, please.
Thank you very much. I want to quickly comment on the issue of localization because that was a very big issue in the last 2019 draft of this bill. And for us not to have the same challenges we had with the last bill, I think it bears talking about at this very important occasion. Now, the 2019 bill imposes the obligation of data localization of controllers under Section 36 and says if you do not localize data in Section 45, you'll be liable to pay 8 billion naira, which was one of the most contentious issues at that time. Now, because of the very robust issues that have been raised by very erudite persons here, I just want to quickly bring this forward. Number one, we need to understand what is the interest being protected in the issue of data. Is the security, business, and privacy. Europe champions privacy as the data subject's right to privacy. America champions the business because they are most of the big data companies, Google, Microsoft, and all that. Then China, Russia champions the issue of security. But for us as a country, we have all these three interests put together because we are a developing country. We cannot tilt towards only security at the detriment of business and privacy. Neither can we tilt only towards privacy and leave business and security to the other side. So in this regard, we need to pick from these three pots and have a balance. That is what is going to happen. So number one thing I want us to quickly agree and bring forward is the data we are talking about here is not critical national information or assets. We are talking about personal data of individuals, and that needs to be clarified because for critical national information, there is no debate about it. We can and we should insist on its localization and for us to have control over it within our territory. That should not be a subject for debate here. So that point we think needs to be properly put out so that because the suggestion here is that if we insist on localization, this law is a principle that guides privacy. Now you are now saying every data, whether critical or non-critical, should be hosted in country. It is going to kill businesses, it's going to kill innovation, it's going to take Nigeria out of the global business framework. And the second point, which is our obligations under the WTO GATT. If Nigeria has not decided to leave the World Trade Organization and some other multilateral organizations that we already have commitments to, there is an obligation we are bound by to say that you cannot do protectionist policies except you are using government money. And that is the reason why the only place we can protect the international transfer of personal data, aside from providing these principles which the secretariat have tried to put now, is for us to say for government data it must be hosted locally. For that, there is no point, there is no debate about that. We can insist to say government data must be hosted rather by Galaxy and all that, but we cannot make every data processing activity to be within to be hosted within Nigeria. And that is the reason why NIDA proposed the issue of data location as opposed to localization. And the philosophy behind data location is that wherever the data is, whether within or outside Nigeria, I'm not talking of government data and I'm not talking of critical national data, but even for personal data, whether within Nigeria or outside Nigeria, you as a data controller must not sign an agreement that removes your control over that data. Because technology now allows you, wherever your data is, you still have a level of control that even the person who is hosting it may not be able to have access to. So what we should be looking at is how do we consider technology to be able to make this possible. So On the final note, my proposition is this, that we can actually have a provision within this bill to say that public data belonging to Nigerian government to be locally hosted and within the logical control of Nigerians, and then we now have the other one to now say with the exception of public data, that data located anywhere in the world should still be within the logical control of the data controller, who will be liable for anything that goes wrong with that data. Thank you very much.
Thank you very much.
I think we need to reward that. Not it should be public data held by public institutions to be hosted in Nigeria. And that brings me to a point here, because I wanted to raise it when Prof or Doctor was talking about local content, about data being in Nigeria, local content, and the rest of it. I think we need to even differentiate between the data itself and the means of holding or storing that data. Because NIPSI learned from a bad experience. You may have the data in country, but the means, the technology by which you are keeping that data, you will not have control over it, because we don't have that local content in country. So we learned the hard way to make sure that the system we build with privacy in design, and to make sure that it's an open system that we can plug and play. That is why, and it's an area that I think NIPDA should really look at, the issue of infrastructure. Like NIMSI is a member of the advisory board of ONSIA, which is Secure Identity Alliance, to make sure that African countries that are into identity, to make sure the infrastructure they use, the technology they use are not locked or closed, to make sure that they are open to be used. Like for example, in NIMSI, any vendor that tries to play something with us, we can yank them up and plug in another system, because we build the system in such a way that we can work around every technology that is available. So please need that. It's an area you need to work on to make sure that the technological infrastructure in Nigeria really adhere to that principle of openness and security. Thank you.
Thank you very much, ma'am.
Hello? Prof wants to make a comment.
Thank you very much. Let me draw our attention to the short title to this bill: an act to establish a data protection commission charged with the responsibility for the protection of personal data, rights of personal data and regulation. Now, you go through the objects in section 1 and the application and scope in section 2. The focus is on personal data, not public data. So if the discourse is to extend the scope, then we'll do that clearly. But for now, what we have here as the short title, the objectives, the application and scope of this bill is personal data. Thank you.
Thank you, Prof.
Thank you, Prof. And I'm standing on just the last statement you just made, because there's a lot of misconception about this data protection, and there's a lot of misconception about when we talk about privacy and the technology behind privacy protection. There's also a lot of misconception, and I think people need to just go to the basics to understand the technology and what does that entails. Because the young man keep on mixing issues about public data and all that. All the most critical data we are talking about is the citizens' data. That's the most critical data. Once that data is out of control, let me just say, for the sake of argument, the doctor from Korea just said something. If you are hosting your data somewhere, and let's just say in South Africa, and there is a dispute, a conflict between Nigeria and South Africa. No matter the type of service level agreement you have, under the national security, the South African government can squeeze the company to just send a virus and destroy that data, and everything is gone. So I think we should try to understand, the technological aspect of the problem we are trying to solve, because all we are trying to do is to be able to protect our data. That's the philosophy about all this. So we should distinguish between, all kinds of data and the data we are talking about. We're so much concerned about personally identifying information of a natural person, which is all the war going all over the world today. So I want to try to clarify that, and with all due respect, I think also the learned gentle people should also try to get the technology people to work together, because this is another thing, the gap we are seeing in this draft, and especially like most of the members of the group, they're all lawyers, and so there needs also the input of people who also understand the technology to help them to fine-tune this in such a way that it will be more encompassing. Thank you very much.
Thank you very much, sir. So this will be the last comment before we round up.
Thank you very much. Very briefly, just to say that two things. One is I'd like the committee to also consider the idea of when this law will come into effect after passage. I think that should be captured in the bill. This is not something that can be left to regulation. We have an NDPR in place now, and it will take time for the Commission to come into play, set up, and begin to implement this law if it is passed. So I think there's a need to provide for that moratorium period, or that transition period, clearly in the Act or in the bill as it is now. Secondly, someone made comments about anonymization of data, anonymization of data. I'm not quite clear on the position of this the committee on that. Can somebody please repeat what was concluded on that matter?
Okay, so what the provisions of the bill does not prescribe the particular technology to be used, but it makes provision for technology to be used in that context. As I said earlier, there was a comment about encryption. So there's anonymization, there's encryption, and there are different technologies that can be used in that regard. The bill does provide for it.
Okay, so my question now is, when a piece of data is encrypted or anonymized, that's no longer personal data in the form that it is. So do these rules apply to that?
The context, let us not forget the context. The context is in the processing. So the anonymization itself is part of that processing. When you go to the interpretation section in the bill, it defines processing and the different constituent parts of processing.
Okay, thank you.
Thank you very much. Before we round up, I directed or asked to invite the members of the Legal and Regulatory Reform Working Group who are here present to just briefly speak to the bill and speak to all of the work that is being done, particularly from the sectoral point of view. So let me ask, I see Mr. Omale from INEC. Let's start with Mr. Omale from INEC, please. Thank you.
Good afternoon, distinguished panelists, ladies and gentlemen. My name is Samuel Omale. I'm here representing my director, who is a member of the group. He has to leave because he has another pressing assignment as well. Well, the group has done a great deal of job, though it's still ongoing. The commission as an institution saddled with the responsibility to conduct elections specified in paragraph 15 of the third schedule to the Constitution. also is mandated to collect data by the provision of the Constitution to register prospective voters. In doing so, we collect data and we keep data. When this draft was sent to us, we looked at it and then we raised concerns as regards to how it affects our work, because it was talking about protection of personal data, being obligated to seek consent. We put all that together, and in the course of looking at the bill, we find out that most of those fears we expressed were being taken care of. We also have the mandate to publish particulars of candidates that are standing for election. In doing so, you collect their data, and we are by law mandated to publish it. We also are mandated under the Evidence Act to oblige members of the public who apply for information supplied to us by those standing for elections. We are able to, by the work so far and the ideas put together, it has been able to come up with the at least remedying, mitigating some of those fears that we have. One area that is so paramount is about data, having our data either domiciled here or outside. Principally, we have our data domiciled here, but we are operating an environment where you don't know what happens tomorrow. So for that reason, we have another option of having it elsewhere. But the idea that it has to be completely domiciled here is that aspect that we are still looking at. And I'm sure as discussion progresses, we'll be able to reach a compromise. Thank you.
Thank you very much, sir. Let me invite Mrs. Umen. Okay, Mrs. Akana, you want to say something?
Yes.
Okay, all right, let Mrs. Akana say something.
Thank you very much for this opportunity. I've been with the sorry. I'd like to extend my pleasantries to the members of the high table and all other participants. Thank you very much for the opportunity to speak. I've been with the working group for the past 2 months, and it's been very hectic. It's an easy thing to come up with a draft, like Prof said. A lot of work is going on, and more work will be going on. And I'd like to quickly just do a brief remark on a few of our comments here. Most of them have already been taken. And our remarks are basically on some omissions, typographical, and we just basically want to do away with the need to avoid ambiguity when it comes to the bill, because I try to move myself out of the working group when I try to read the bill and to just try to read the mind of the drafters. That's what I do most of the time. I noticed that we've worked on the gender aspect of the bill, because somebody looking at the bill will say, are women there? Why does he have to say him all the time? Because we have done away with the era of one gender representing both. I know we worked on it, but it doesn't seem to appear here. And then I know there are some phrases that maybe just came up in the draft. Maybe they are omissions, or some of them are omissions, and so they leave some of the sentences in the sections hanging. I'll officially send our comments, which will be about 2 or 3 pages, so I don't intend to read everything here. And I'm happy to be part of the working group, so work will continue. Basically, section 42, which has to do with regulations made in the Act. And then there's the purpose of enforcing the provisions of the Act and regulation made pursuant to the Act. That is what should be added there to Section 42, subsection 1. I don't intend to read all this. And then concerning removal from office, it looked like if you have to remove somebody from office, all the circumstances mentioned in that chapter may have to be fulfilled. So maybe we may just need to add any of the following circumstances. And then in qualification, it looks like you may need to have more than one of the professional qualifications mentioned there. So we may need to, because reading it, if we don't, because I know that a single sentence may change an entire page or an entire paragraph, and we don't intend that our bill, as simple as it is, should be subject to judicial interpretation before it is implemented. We don't intend that everything we do should go to court before we get a clear meaning. That's basically I just want to round up. I don't want to waste anybody's time.
Thank you very much, madam. Thank you very, very much. May I respectfully call on Mrs. Eze from the Nigerian Communications Commission. Thank you.
Good afternoon, everyone, and I will rest on all existing protocols. Basically, we have been a member of the working group right from the beginning, and I'm here to represent the Director, Legal and Regulatory Services.